afternoon and welcome to the special LNTV broadcast. My name is TETEE GEBRO. Well, in case you don't know or you haven't heard, members of the Ecowas Court of Justice are here in Liberia on an outreach. But this afternoon, we are playing host to the Chief Registrar and the Executive Assistant to the President of the Court to tell us why exactly they are here and what this outreach is all about. So stay with us. We'll be right back after this break.
Oh, hail Liberia, hail! Oh, hail Liberia, hail! This glorious land of liberty shall long be ours. Thorn you her name, green be her fame, and mighty be her power, and mighty be her power, and mighty be her power. Boom, 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 in joy and gladness, with our hearts united, we shout the freedom of our race benighted. Long live Liberia, happy land, a home of glorious liberty by God's command, a home of glorious liberty by God's command.
Indeed, this is a glorious home of liberty by God's command. Welcome back to this program, but we're talking about ECOWAS, and ECOWAS consists of 15 member states, and we're talking about ECOWAS today. As I said earlier, the members of the ECOWAS Community Court of Justice are in Liberia, and they're doing an outreach. And so we have these distinguished gentlemen here who are going to tell us all about the outreach they are on in Liberia today. Welcome to the program, Mr. Anthony Anini Miado. Am I right?
Anini Maido.
Anini Maido. Welcome to the court. Welcome to this program. Sorry, he's the Chief Registrar of the court. Welcome. And then we also have with us this afternoon in studio the Executive Assistant to the President of the court, and he's Nketia Apriku.
Yes, sir. You're welcome.
Thank you for being with us today. And the main reason why you're here this afternoon is to tell us your mission in Liberia, or the court's mission in Liberia. So I'm going to start with you, the Chief Registrar, to tell us what exactly you mean when you say the members of the court are here, on an outreach. What is that? What is the ECOWAS court, in fact?
Thank you very much.
Okay.
The ECOWAS Court of Justice is the principal legal organ of ECOWAS. It is one of the main institutions of ECOWAS. And we are here on an outreach program. We have a delegation that is led by the Honorable President of the Court, Honorable Justice Edward Amako Asante. The other 4 members of the court, that is the Honorable Judges of the court, are part of the delegation, and some key officials of the court. We are here on an outreach program as part of our program for the year. And this time, the court decided to visit 3 member states, this year. And the Republic of Liberia happens to be one of the states we are visiting. The outreach program is an advocacy and sensitization mission in order to create awareness among stakeholders in the community, the member states, institutions of the state here in Liberia, and the community citizens of ECOWAS in Liberia. The program is for 1 week, starting from tomorrow. And tomorrow we are going to have court visits to high officials of state, starting with His Excellency, the Vice President of the Republic. We will also be visiting the Speaker of the Parliament, the President of the Senate, we call it the Chief Justice of the Supreme Court, the Minister of Planning, the Minister of Foreign Affairs, and the Attorney General Minister for Justice. These are the high government officials we are going to see tomorrow. And after that, on Tuesday, we are going to have a major sensitization campaign, followed on Wednesday by a bar forum in which we'll be meeting members of the bar and lawyers. And on Thursday, we are going to have a town hall. And finally, on Friday, we'll be rounding up on Friday with a judicial dialogue between the honorable judges of the court and the honorable judges of the National Court of Republic of Liberia, followed by a press conference. So it's a one-week activity, and we promise that it's going to be very interactive, it's going to be quite engaging, and we value the community citizens. As a community court and as an institution of Ecowas, it is important for the stakeholders in the Republic of Liberia to know actually what we are doing. We want to create awareness about the mandate of the court, the competence and jurisdiction of the court, the practice and procedure of the court, and even the relationship between the court and the national courts of member states. During this sensitivity outreach program, a lot of presentations are going to be made. We are going to make presentations on an overview of the Ecowas Court of Justice, speaking in very broad and comprehensive terms, followed by presentations on the jurisdiction and mandates of the court, the practice and procedure of the court, women's rights, and finally on the relationship between the judges of the courts and the judges of the national courts in the judicial dialogue we talked about. We've recorded a lot of successes. We equally have challenges. All these ones are going to be x-rayed during this outreach program. And finally, stakeholders will have the opportunity of asking us questions. So as I said, it's going to be very engaging. It's going to be very interactive.
Great.
Thank you very much.
Yeah, from what I gathered from you, it's like you guys are on, a mission to make sure that stakeholders in Liberia kind of understand the mandate of the court, the jurisdiction of the court, and what the court is all about, so they can also be more interactive. But let me ask you, Mr. Apriku, when was this court established?
I would prefer that Monsieur answer that question.
Okay.
Thank you very much. The protocol on the court was adopted by the member states in 1991. And as you know, equally important to note that the court was established as a tribunal under the Lagos Treaty of 28 May 1975. That is when Ecowas was established. It was established by a treaty. That was the 1975 treaty.
1975
treaty. Okay. But no, that was when there was provision for the establishment of a tribunal. Okay. But the court wasn't set up. So under the revised treaty again, which was adopted in 1993, the court was established again under the revised treaty. But it is important to note that despite the provisions that were made in that Lagos treaty, the revised treaty, and the protocol on the court that was adopted in 1991, the court did not become operational until 2001.
Okay, so you became operational in 2001.
That was when the pioneer members of the court were sworn in. So we came into being in January 2001 when the 7 pioneer members of the court were sworn in.
Okay, so since January 2001, when did you start this kind of outreach?
Well, we have been doing outreach for a long time. We have been to the Republic of Liberia for an outreach program of this nature about 10 years ago, in 2007. We were first here in 2007, but that's a long time ago, so we are coming back again, because the court has changed a lot since that first outreach program was undertaken here. So it's good to let stakeholders here know what has happened in the intervening period.
Okay, great. Let me ask you again, when you say, the court was established, you started your operation in 2001, right? And you've been to Liberia. This is your second time on this outreach. What was different from what you're doing now to get stakeholders involved?
What is different is that the mandate of the court has been expanded. Although as at the time we first came here in 2007. The mandate has been expanded, but the effect has not been brought to bear. But now we can say definitely that because of that expansion that was done in 2005, that the court is a different place, because this jurisprudence has grown tremendously. The number of cases filed before the court has equally increased tremendously. Again, there have been changes to the membership of the court, which we are equally going to talk about in this program. Some of these changes, we believe, are of grave concern to us, because we don't think that they are good for the courts.
Okay, great. So let me come to you before we go to the mandate of the court, and because I know even though you're here to talk to stakeholders, but then Liberians also are also interested in knowing exactly what the court can do for them and how they too can use the court. Correct me if I'm wrong, Liberians can also use the court, right?
Exactly.
Okay, so I know people will be interested to know, as citizens of ECOWAS, member state, as citizens of an ECOWAS member state, what they can, how the court also can be of use to them. But let me come to you, because you are the executive assistant to the president of the court. The president of the court is here, right?
Yes.
Is in Liberia.
Yeah. In fact, all the 5 judges.
All the 5 judges of the court are in town. So who all are you meeting besides those who are in higher positions in the country? I heard him talk about the finance minister. I heard him talk about the minister of justice, the speaker, the president pro tempore, the president if he's in town, or the vice president. But besides that, are you meeting ordinary citizens or students? Because I know you're meeting lawyers, but are you meeting ordinary citizens also?
I think as a CRSL, tomorrow, which is day 1 of the event, is when we are meeting the dignitaries.
Okay.
That is the vice presidents, the minister responsible for ECOWAS affairs, and then the attorney general, chief justice, and speaker. But when you go to day 2, which is Tuesday, our audience actually are members of the Bar Association, officials of immigration, customs and police, journalists, civil society organization, women groups, academic, deans of faculty of law, ECOWAS national office reps here. So that is for the 2nd day. But when you come to the 3rd day, also we have members of the bar who are also part of it, and then the public, law lecturers, law students, university students. And on day 4, that is a town hall open forum given to members of the public. And here the audience is going to comprise of ministers, media practitioners, other government officials, civil society organization, women group, police, immigration, customs, ECOWAS ambassadors, special representative of ECOWAS. So on the Thursday, it's like we're going to open the doors of ECOWAS to the general public.
Okay.
Women, students, every man in the street. You open to come to the town hall, and the place is Boulevard Palace Hotel. That's where we are going to engage them. Before Friday, then we get to the judicial dialogue with our members or judges of the Supreme Court.
Great. You wanted to chip in? You want to say something? Okay, let me come back to you. What is the jurisdiction of the ECOWAS Court of Justice?
I want to speak in terms of mandates before we can now
go to jurisdiction.
Jurisdiction. But in terms of mandate, the court has 4 clear mandates. The first mandate, following the adoption of the supplementary protocol in January 2005, the court retains its basic mandate of being a community court.
Community court. What does that mean?
Under this mandate, the principal function of the court is to interpret and apply the provisions of the revised treaty. The protocols
interpret and apply
yes,
the provisions
of the revised treaty of ECOWAS. The protocols of ECOWAS, conventions of ECOWAS, the subsidiary instruments of ECOWAS, like regulations, directives, all these are part of that mandate. It also included in that mandate is the giving of advisory opinion, which the court has power to do to member states and institutions of the community. In addition, the court is also, an administrative tribunal for ECOWAS public servants. So, in this mandate, as a community.
What do you mean when you say it is, an administrative tribunal for ECOWAS members?
I will explain that.
Okay.
So, the first mandate, there are 4 mandates, as I said. The very first mandate is mandate as a community court. The second mandate is the mandate of serving as an administrative tribunal for ECOWAS public servants. ECOWAS has a lot of staff. if these staff have disciplinary procedures, you know, in any of their institutions, and they are not satisfied after exhausting those remedies, you know, before their various institutions, they can appeal to the Ecowas Court of Justice if they are not satisfied. That is what we mean by that. So it's Ecowas Court serves as the final court for Ecowas officials who are facing disciplinary procedures and are not satisfied at the institutional level. They can appeal to Ecowas Court of Justice.
Let me come back a little bit. I want to understand it, because when you talk about ECOWAS institutions, ECOWAS officials, are you referring to a specific group of people or everyone who is a part of, you know, the ECOWAS member state?
No, we are talking about the staff employed by ECOWAS institutions.
Only the staff?
Yes. When you talk about staff, ECOWAS institutions are talking about the ECOWAS Commission, ECOWAS Parliament, ECOWAS Court of Justice, GEBRO, West African Health Organization. These are the institutions of ECOWAS we are talking, and they employ a lot of staff. So for these various institutions, if any staff in any of these institutions is undergoing a disciplinary procedure and he or she is not satisfied, she can appeal the decision at the institutional level to the Ecowas Court of Justice.
Okay.
That is why I say it starts as an administrative tribunal. That's the second mandate. The third mandate, which is the most prominent mandate of the court now, is the human rights mandate. It's a human rights court. And most of the cases filed before the court now are in respect of that mandate. And the final mandate it has an arbitration mandate. That arbitration mandate was equally given to the court by the 2005 amendment of its initial protocol. As I said, this mandate is not yet operational.
Why?
Because the rules of arbitration have not yet been approved by Council of Ministers. As soon as the rules of arbitration are approved by the Council of Ministers, that mandate equally come into operation.
Is there any set time when the rules are going to be approved?
No, that is not within the purview of the court's competence. It is the Council of Ministers. But then, before the Council of Ministers will consider the rules of arbitration, the legal experts from the member states are supposed to come and look at that document, and once they are the ones to now recommend it to Council for approval. These are processes that are under the purview of the Ecowas Commission and not the courts.
Okay, so to sum it up, then it means that when I hear you talk about ECOWAS court, you have limitations, right? You have straight jurisdiction over over your institutions and those who work for your institutions, and not all the members of the community.
No, that's not correct. We'll have our jurisdiction. Every court has a jurisdiction. Okay. That is the power a court has to entertain a matter and to hear a case. Every court must have a jurisdiction and cannot work outside its jurisdiction. Okay. We have spoken in broad terms about the mandate we have, but a subset of that mandate is the jurisdiction we are talking about now. Let's take the human rights mandate, for instance. The human rights mandate simply gives the court the power to determine cases of violation of human rights that occur in any member state. So we have territorial jurisdiction across the 15 member states. So any human rights violation, for instance, in the Republic of Liberia, the victim can choose to come to the Ecowas Court of Justice to seek redress.
Oh, really?
So these cases come from the member states. They emanate from the member states, from private citizens in the member states. The human rights mandate of the court is so broad, and it also has an interesting feature. The interesting feature is the fact that you can choose to come directly to Ecowas Court of Justice without exhausting local remedies in your country, without having to go to the courts in your country. That is the procedure that is followed by other international courts. But the Ecowas Court of Justice is peculiar in this sense. So it's an advantage that the community citizens in every member state can choose to come directly to Ecowas Court of Justice to seek redress instead of going to the courts in
wow.
country.
So if I, as a citizen of Liberia, feel that my right has been violated, I can jump over the courts in Liberia and go to Ecowas Court, and you will hear that case, and whatever mandate
we hear that case because we have been given a very broad mandate, but we'll equally let you know that the jurisprudence of the court has equally delimited the scope of that human rights mandate.
How?
You cannot bring your landlord before the Ecowas Court of Justice. You can only bring a member state to the court to say that the member state has the responsibility to protect your human rights, and your human right has been violated by the state directly or by an agency of the state.
Okay, so your rights have to be violated by the government of Liberia or an agency,
or that the government has failed to protect your right. It may not be the fact that the government has directly violated you, but that the government has not lived up to its obligation of protecting those rights.
So it's kind of tricky then, because if I'm going to the ECOWAS court to say that the government, let me use Liberia for an example. Liberian government has, failed to protect my rights. How do I explain that to the ECOWAS court when I've jumped over Liberia, right? I feel my rights have been violated, and then I jump over the courts in Liberia and go to the ECOWAS court.
I will give you 2 instances.
Okay.
We are not talking about governments. We are talking about member states. That you must know that. The member states have a responsibility to protect your human rights.
Okay.
So, if, for instance, an agent of government, a policeman on the way, shoots somebody in the course of his official business, and that act is attributed to government. The government didn't come directly to shoot you, but an agent of the state. Okay. That is one. I'll also give you another example where you have, for instance, you have.
So then, in your first instance, then it means that case was not heard, or the government paid no attention to the case. Then you have the right now to go to the ECOWAS court.
You have the you have. I'm just giving you an example. That happened.
Okay.
I also give you another instance. Maybe, for instance, there is a civil disturbance, uprising or something, and something happens to you in the course of that uprising. Of course, that's also another instance. We are just giving instances. All we are trying to say is that you are not going to bring another individual to the courts. You are bringing a state party to the court on the ground that state party has an obligation to protect your rights and did not do enough to protect your rights.
What do you do as the ECOWAS court? Maybe you could answer that question. If like for instance now, someone decides to take, like for instance, you say, okay, the person was maybe shot by a police officer, and then their rights were violated, and then that person decides to go to the ECOWAS court. After you should have, gone through the whole case, how does that person get, what is your mandate over your members to make sure that, for instance, the government of Liberia does what it should do in that case after violating the rights of the person?
Let me come in there. In Liberia, if you want to assert your right against the government, you look at the statutes, the laws passed by Parliament, and you say that this is the right that an act has given me. If the state is not living up to this responsibility, then you go to court to assert your right based on the statutes that are operational in the country. With ECOWAS, we apply the right of citizens based on international treaties that Liberia has subscribed to. So we do not apply the local laws, but rather international treaties and conventions that Liberia has subscribed to and become a party. Those are the texts that we use to establish the right of a person to assess whether a violation has taken place or not.
Okay, so when a violation has taken place and you tell the government that a violation has taken place, you wrong this person, how do you mandate the government now to do what is right?
Exactly. That's what CR was trying to explain to you, that where the state itself is not very firm up whether a right has been violated or not. The statutes of ECOWAS, that's the protocol, give you a chance to seek clarification from the courts. We call it preliminary ruling. That how do you interpret this convention or this statute? Then the government of Liberia will now act upon the advisory opinion that is given. However, if it becomes contentious, that is, a party comes before the court suing the Republic of Liberia for violating of its rights, we look at the text, and then we give opportunity to the Liberian government to respond to the accusations by the person who is claiming that his rights have been violated. And the matter becomes a contentious one. So he will prove his case against the government of Liberia. Liberia will also respond. And after using the text that is the subject matter of our breach, then at the end of the day, a verdict will be produced by the court. If the verdict is in favor of the person who came to the court that his rights have been violated, then appropriate orders will be made by the court. It's in varied form. Sometimes it could be just restoration of the right, and you will not be given any compensatory damages. sometimes too, the court can order the Liberian government to pay compensation as a result of the breach or violation of your right. So it depends. After that has been done, there is another process that the court expects member states, and which is also part of the laws of ECOWAS, to go through for the enforcement of the judgment delivered by the court. That one is expected of a member state to designate a body within Liberia that will implement or enforce the judgment of ECOWAS court. And that enforcement should go in accordance with the orders that were made as a result of the hearing of the case.
Do you have these bodies set up in all of the ECOWAS
It's
nations?
one of the challenges that I was talking about. That out of the 15 member countries, I think currently we have only 5 of the member countries that have actually put in place mechanism for enforcement of the judgment. So as a matter of course, this sensitization is geared towards appealing to member states, not only Liberia, but other member states that have not subscribed or put in place mechanism for the enforcement of judgment to do so. Because at the end of the day, if the court goes through the judicial process to produce a judgment, and then the states that's supposed to enforce the judgment are not enforcing, of course the court's utility will not come to bear in the life of its citizenry.
Okay.
Yeah, I mean the ECOWAS citizens.
I see. That's why you're meeting stakeholders to make sure that this
exactly,
happens.
so that they understand us from that concept that you give us right to do A or B. And at the end of the day, after that has been done, what is expected of you to perfect what the court has done? If you fail in your responsibility to do that, it's as much as good that you didn't even put the court in place.
Okay. Which is great, because, and how has it, when did you guys get in Liberia, and how has the reception been?
We just got into Liberia yesterday.
Okay.
And the reception has been very good. We are looking forward to the program starting tomorrow.
The program which starts tomorrow.
And actually, if I may update you, it's not only Liberia. As the registrar said, this year 3 countries are earmarked for this sensitization or outreach program, and it started in Sierra Leone.
Sierra Leone.
So, yes.
Okay.
So the CR and the judges were there, and other staff of the court, including myself, joined them in Liberia.
In Sierra Leone?
Yes. From
Sierra
Liberia.
Leone?
Yeah, from Sierra Leone.
Okay.
And then from here, date has also been set for Cape Verde.
Okay, we'll soon go for a short break, but before we go for the break, I want to know whether what you've started, the court had its, renewed mandate, and you started since 2001. Have you, are there cases you've dealt with in member state countries?
All the cases come from member states.
Yeah, but how many cases have you
since inception, a total of 399 cases.
299?
Yes,
wow.
399, almost 400 have been lodged so far before the court. So we've dealt with them, and presently we have 103 cases pending before the court.
Oh, wow.
The court has given a total of 107 rulings, 208 judgments, and 18 decisions on review. We have equally given 4 advisory opinions. And all these cases come from member states.
Okay, let's take this short break. When we're back, we'll talk about, the rulings and how member states took those rulings. Let's take this break.
In the name of the Father, the Son, and the Holy Spirit, all power and glory belongs to you. In the name of the Father, the Son, and the Holy Spirit, all power and glory belongs to you. Olengwe ike mmadụ jakari ike Chukwu. Olengwe ike mmadụ jakari ike Chukwu. Thank God he said, man no be God. Thank God he said, man no be God. My name is Sima Chiwifo. I come from West Africa, Liberia. I thank God for my life. I thank God for my health. I thank God for my family.
earlier, we've got members of the ECOWAS Court of Justice here in Liberia on an outreach. And to know more about this outreach, we've got the Chief Registrar of the court and the Executive Assistant to the President of the ECOWAS Court here who are telling us more about their mission to Liberia and what they expect to achieve following this mission. Mr. Tony Anini, right? Anene Mando is the Chief Registrar, and Mr. Nkete Apreku is the Executive Assistant to the President of the Court. Welcome back again, gentlemen. Before we went for the break, you talked about almost 400 cases the court has been able to hear, right? And that's a lot. Those cases are many. You've got 100 plus still on the docket, right?
103.
Okay, so 100 plus still on the docket. But let's know the responses from, member countries after the court came up with the verdict. Was it responsive? Are they responding to the verdicts of the court, or has there been, an upheaval as a result of your
The member states generally have received the judgments of the court very well.
Okay.
But the issue is one of compliance, because we have not received any protests from any member states against any judgments of the courts.
Okay.
But the main question is, are they being complied with? I would say roughly about 30–40% of the judgments of the court have been complied with. But apart from that, we've not received any adverse reaction from any member states regarding the judgments of the court.
But they are, they're members of ECOWAS community, so they know that you have the right. They've given the court the mandate to carry out, this job. So I'm not sure that they will be, against your mandate. But compliance now, how will you get them to comply to those mandates?
There are two options.
Mm-hmm.
The first option is to comply. Mm-hmm. Immediately the judgments are given, mm-hmm. because the revised treaty and the protocols on the court provide that the judgments of the court are binding on member states, mm-hmm. institutions of the community, individuals and corporate bodies. The protocol on the court enjoins the member state to immediately comply with the judgments of the court. It's an immediate thing. There's no time frame there. They will immediately comply with the judgments of the court. So it's a treaty obligation they've already entered into. Mm-hmm. They established the court. It's their courts. But having said that, the 2005 supplementary protocol now provided for a method of enforcement of the judgments of the court. And it gives the member state the responsibility of enforcing the judgments of the court. The role of the court is just to give the judgment. And once the judgments are given, it now becomes the responsibility of the member states to, enforce that judgment in accordance with their rules of civil procedure. So internally they are to enforce it. Secondly, they are enjoined to appoint a competent national authority that will be responsible for the enforcement of the judgments of the court. And that is where the problem is.
Who pays those people who are appointed in a member state?
The agencies, the agents of the state, the institutions of the state. It's the responsibility of the state, so the state has the responsibility to do that. Some member states have appointed, for instance, like Nigeria, appointed the Attorney General and Minister of Justice as the competent national authority responsible for the enforcement of the judgments of the court. So we are saying that you don't really need to take measures to maybe go to a court of law in Liberia to now enforce this judgment. If you can simply comply with it, immediately they are given.
It's kind of tricky though when, like for your country, for Nigeria, where Nigeria appoints the Attorney General to head that aspect, right? What if a mandate comes from the court, that is the ECOWAS code, and then, like you talked about, difficulties in implementing the mandate from the court. First question is, are there penalties for member states that are not complying with your mandate too? And I was saying, if the Attorney General is the one who heads that code, what if he doesn't comply? What happens?
It's not about the Attorney General, it's about the state.
Yeah,
it's a state responsibility.
Mind you, a member takes a complaint because they don't trust that case will be heard by their government, and then it is taken to the ECOWAS court. And so you
not necessarily because they don't trust. They don't bring the cases here because they don't trust their government. They are
because the government is not listening to them or not doing what.
No.
Okay.
They are seeking redress at a regional level.
Okay.
We are not going to the reasons why they have chosen to come to the regional court instead of going to national court. So we are not going here to pass judgments on that.
Okay.
You know, some could want the profile of going to a regional court, not because they don't trust their regional their courts here. So we cannot come to that.
But one of the reasons why they might be doing it is because they want to make sure that, you know, whatever judgment comes out of there is adhered to.
We cannot say. What we are saying that they have an option.
Okay.
They have an option to go to the national courts or to come to the regional courts.
And I go to the regional
if they
court.
come to the regional court, they are coming there to engage the responsibility of the state. Remember, that is not all cases that they can bring. If you have a problem with your wife, you have a problem with your landlord, you cannot come to the Ecowas Court of Justice. You only come in where you're engaging the responsibility of the state, because the state has a certain responsibility, which you feel that the state has not been able to maybe live, to fulfill its obligation. So that is what is bringing you before the regional court. Sure. When you are coming to the regional court, it's not against any other party other than the state. So it's the state we are talking about now. And when judgment is given, just as we said, the protocol on the court says the member state will enforce that judgment in accordance with their rules of civil procedure. It equally says that we appoint a competent national authority. Some countries appointed the chief registrar of the Supreme Court as the competent national authority. Some appointed the minister in charge of Ecowas affairs. Some appointed the attorney general and minister of justice. It's up to the state to choose who to appoint. But once the person is appointed, the person is to bring measures at the local level, municipal level, to ensure that the judgments of the court are enforced. We must remember one thing we keep saying, that is a treaty obligation of the state. It is not about the official. It's not about the attorney general. And there are instances, I'll give you an example of a country like Niger Republic, where they have not appointed a competent national authority up to date, but they complied with the very celebrated case of Adija Tumani Koro against the Republic of Niger. Even without appointing a competent national authority, they still comply with the judgment. So compliance is the word here, is the key here. And we are saying that the member states set up these courts. They have an obligation to comply, with the judgments of the court in good faith.
In good faith.
Yes.
So it means even if they don't do that, you're just asking them to do that in good faith. Yeah,
because they know that that's the obligation. And Pacta sunt servanda. It's a lag.
And there are no penalties if you don't, right?
As I said, it's a community court. The court belongs to the member states. The member state sets it up, and for the court to be credible, the judgments of the court have to be respected. There are provisions in the revised treaty and in the supplementary act that provides for sanctions where the member states don't fulfill their obligations. Not respecting the judgments of the court or complying with the judgments of the court is a violation of the treaty obligation of every member state that fails to comply. It's a treaty obligation. And there are three texts. One, Article 77 of the revised treaty provides for sanctions where a member state fails to fulfill its obligation. Secondly, in 2012, the community adopted a supplementary act on sanctions against member states that fail to fulfill their obligation. And there are two elements to that 2012 supplementary act. One is political sanction, and the other one is judicial sanction. So there are sanctions, but I can tell you that none of this has been applied so far as the court is concerned.
So let's talk about, I know you're here because you want to improve the relationship between the National Court and the CCG, right? Yes. On the overall, have you been getting, good responses from the national courts, or is that one of the reasons why you're organizing these forums?
We have a good relationship with national courts, but there's always room for improvement.
Okay.
And that is why in this program, there's room for, we are provided for a judicial dialogue between the courts, the Ecowas Court of Justice, and the judges of the National Courts of Liberia. That judicial dialogue is for them to sit down together and be able to look at, these issues and see the ways and means of improving the relationship. But it is important to note that the text of the Ecowas Court of Justice has provided some framework. It might not be perfect, but we are, number one is that the judgments of the court, Ecowas Court of Justice, are to be enforced by the national courts. The second one, just as my colleague alluded to earlier on, there's the provision for reference. If there's a matter going on before a judge, in Liberia, for instance, and the issue of interpretation and application of the Ecowas treaty comes up, the judge, either on his own motion or the request of the party, is supposed to refer that issue to the Ecowas Court of Justice for interpretation, and after to send back to the National Court for him to use in his judgment. That is, what he refers to when he talks about preliminary ruling. So unfortunately, that has not yet been done by any judge in the member states.
So you want them to do that and start to enforce what?
So that's just an example of what we are talking about. And apart from that, we have other programs like, just as we mentioned now, we have external court. We do external court sessions, in which case the Ecowas Court of Justice leaves his seat and comes to the member state, maybe in the Supreme Court of a member state, to sit.
Oh wow!
To sit.
Do you do that on a yearly basis?
We do that on an annual basis to sit. And when we do that, the judges of the court pay courtesy calls to maybe the judges of the Supreme Court. We have interaction with them, And a few years ago, the Ecowas Court of Justice actually, engineered the setting up of West African Jurists Association, what it refers to as JOI, in order to bring together judges from the national courts and the judges of the Ecowas Court of Justice.
Has it been set up?
It has been set up, for them to...
Have they met?
The inaugural meeting was held in Cote d'Ivoire about 2000, few years ago, about 2015. So that's just part of the thing. And more importantly, in the judgments of the courts, the court has consistently said in its jurisprudence that it is not an appellate court over the national courts of member states. The court has said it will not review the judgments of a national court. If you are not satisfied with the judgments of a national court, you follow the appeal processes in your country. Don't come to Ecowas Court of Justice to say, I'm not satisfied with the judgment given by the Supreme Court. I want you to... The court doesn't have that power.
Oh, you don't have that power.
You don't have that
power.
when
the Supreme Court of Liberia rules,
it's
that's
final.
The final.
The court cannot go and say we are sitting on an appeal over the decision of the Supreme Court of Liberia. So these are the issues. The court has tried to... And the court has said that the relationship between it and the national court is not of a vertical nature, and that the Ecowas Court is sitting at the apex there. No. So the court knows that, according to it, we have an integrated community legal order. So we're all working together because their mandates are different. The only area where we have maybe concurrent jurisdiction is just the issue of human rights. And even in that human rights, the court has said it's an international court and can only hear disputes that have international character. Anything that does not have international character, you cannot bring before the Ecowas Court of Justice. Go to your domestic courts.
Great. But let me ask you, before we come to the challenges you guys are faced with, I hear you say you guys are also meeting women groups and students. Does the court mandate member state to have, programs in a country where people in Liberia, I'll use Liberia for example, to know all of what, happens at the court and what you can do as a citizen and what cases you can take to the Ecowas court, just so that people in member state know what exactly happens at the Ecowas Court of Justice?
Well, if I may take it from an international law perspective, when countries enter into treaties or conventions, it is their obligation to reduce it into their own laws for application. So what is it that I've already told you? All the court applies, all the texts that the court applies are international in nature. So it is expected of every member to reduce the laws that they have subscribed to or they have, let's say, entered into at the international level within their domestic laws, so that people within the country will know what is expected of them, what their rights are against the government. Once that is done, it is at that point that a person will know that this right is mine and the government has violated it. For that matter, I have access to the Ecowas court to reinforce my right.
Okay, so the court believes that every member state should reduce that into...
But in fact, it's an international principle.
Is it... Yeah, it's a mandate that they should...
If I can clarify that a bit. The Ecowas Court of Justice does not apply the constitution of member states.
Yeah, understood.
The Ecowas Court of Justice applies the revised treaty, and in respect of its human rights mandate, the international human rights instrument that member states are signatories to. For instance, the African Charter on Human and People's Rights, the Universal Declaration on Human Rights, International Covenant on Civil and Political Rights, International Covenant of Economic, Social and Cultural Rights. Those are, I'm just giving you an example, for instance, of what the court does. The court is basically the international human rights standards that the court applies, not the constitution of member states. So if you are before coming for the Ecowas Court of Justice, you are coming on the ground that a provision of any of these international human rights instruments have been violated by the state. So that is, but going beyond that, the ECOWAS revised treaty in Article 5.2 enjoins every member state to domesticate the ECOWAS revised treaty. So what we are talking about is that, it is when these international treaties that the member states have subscribed to or acceded to are domesticated into the laws of the member state that, the man on the street will become aware that this African Charter is now a law of Liberia, not just an international human rights instrument adopted by Liberia, but it has been domesticated and transformed into part of the laws of the country.
Okay, great. So let's talk about the challenges you face.
We'll talk about, the court has some challenges, and the first one I want to talk about is about the tenure of the judges. The first one, when the judge, under the 1991 protocol on the court, we set out the composition and powers of the court. The court was composed of 7 members. 7 members, and the tenure was staggered in such a way that 4 of those 7 initial members had a tenure of 5, and the other 3 had a tenure of 3 years. But both of them were renewed for 5 more years when they expired. So the initial members spent a total of 8 years and 14 years in the court, respectively, because of the staggered nature. It is important to have a staggered nature so that all the members of the court don't leave at the same time. Because when they leave at the same time, it creates a problem that all of them that are coming in are new. No institutional memory. And that is the problem, the first problem we are facing now. In 2014, all the members of the court left at the same time. In 2018, all the members of the court left at the same time, which is a problem. We are advising that it is good to follow the initial protocol that had this provision for staggered tenure for members. So it is no longer being followed, and we feel that that is a cause for concern for us, because when all of them come in at the same time and leave at the same time, it is a community that is losing valuable resource. They gather experience and they all leave at the same time. Nobody is remaining on board, for the incoming ones to know
to learn from. Okay.
That is number 1. Number 2 is that at the beginning, the tenure of the judges was renewable. You have a tenure of 5 years, renewable for another 5 years. That is why you can even serve in the court for 10 years. And as I said, the initial members, some of them, 4 of them, spent 14 years in the court. So, but that is no longer the case.
Non-renewable.
Yes. In 2006, it was reduced to 4 years non-renewable. We feel that 4 years is too short a tenure for a judge of the court. By the time they come here on board, they learn the ropes, for them to start applying, for you not to start to benefit from the wealth of experience they acquired, we are asking them to go. So we feel that there's no international court that has that to say.
So what are you proposing?
Even the initial protocol on the court said 5 years, renewable for another term of 5 years.
Do you want that to be?
We are saying that 4 years non-renewable is not good, because that was done to harmonize with the political appointees in the ECOWAS Commission. Judges cannot be treated like political appointees, and that is the point we are making. 5 years renewable for another 5 years term, or 7 years, or 9 years non-renewable. Whatever, but give us an option that extends the current mandate of 4 years non-renewable. Even if it's going to be 4 years, let it be 4 years renewable. But to have 4 years non-renewable is a second challenge I mentioned. And the final challenge concerning the tenure of judges is that 2 years ago, 2017, a decision was taken reducing the number of judges from 7 to 5. So now that's why when we started the program, we said that the 5 members of the court are here with us. It's supposed to be 7, because that was the initial mandate provided for. And unfortunately, this is coming at a time that the workload of the court has increased tremendously. So now, for a case to be handled, you need a panel of at least 3 judges. With 5 members, it means you can only have 1 panel at a time. You cannot constitute 2 panels for 2 different matters at the same time. For them to be working or sitting simultaneously, it's no longer possible. And apart from that, the workload of the court is increasing every year. From 2014, as I mentioned at the beginning, in 2014, 41 cases we received in 1 year. And we said, oh, that's a lot of cases. As at 2018, 61 new cases were filed. We expect that this year, 2019, it will exceed that 61 cases that were filed last year. So the workload is increasing because the community citizens are becoming very much aware of the existence of the ECOWAS Court of Justice, and they are taking advantage of it. With this sensitization and outreach program we are having in the Republic of Liberia, we are going to see that there's going to be an upsurge in the number of cases that will come from Liberia. From inception till now, a total of 14 cases have been received from Liberia. But we expect that it will go up.
With the awareness now, it's most likely to increase. Yeah. So how these are challenges you face with,
those
right?
are in respect of the tenure.
Okay.
Well, we also have another major challenge in respect of the enforcement. I've talked about it briefly, in the sense that the member states are supposed to appoint the competent national authority for the enforcement of the judgments of the court. Only 5 member states have done so: the Republics of Guinea, Nigeria, Mali, Burkina Faso, and Togo. It is our hope that
Liberia will okay, great.
Join the bandwagon by appointing a competent national authority,
which is a good thing, and we believe that our government will also join that. But we'll soon go because we're running out of time now. But let me ask you, these challenges you faced with, how can these challenges be resolved? Is it through explaining at these dialogues with member states, and then you meet and talk about them?
Is by engaging the member states. It's by engagement, drawing their attention to it. Sometimes these things are not willful. Sometimes it's because the attention has not been drawn to it. So that is part of the advocacy with high government officials. Okay. When we go to meet with the Vice President of the Republic, you can be sure that that's one of the problems they are going to raise. When we met with the Vice President of the Republic of Liberia, of Sierra Leone, we raised it, and he promised immediately that they are going to do something about it. Okay. So sometimes it's due to lack of awareness about these problems. I also give you another example. I know that the President of the Court, Honorable Justice Edward Amanko Asante, discussed this very problem with the President of the Republic of Ghana. And the President of Ghana said, we are going to take action immediately on it. So sometimes it's because these things have not been brought to the attention of high authorities. And that is the advocacy element of this outreach program.
Thank you so much for being with us today. But let me just get your final, your parting comments, because we're totally out of time, and I know that these outreaches in Liberia here will, help us and even our government officials understand exactly what they need to do to play their part to make sure that the ECOWAS Community Court of Justice is up and running.
Very well. Liberia is a very live constituent of ECOWAS. And this outreach program is organized for the benefit of the citizenry of Liberia. We expect that at least the open forum that will be held at Boulevard Palace Hotel, all the people are trooping in there for us to educate. If they also have any concern, they bring it on board so that we build the synergies towards a better mentality of treatment of human rights within the ECOWAS sub-region.
Thank you, Apriku.
We are here to engage all stakeholders. So we'll be happy if all stakeholders can come on board and be part of this outreach program. It's an interactive program. It is designed for them, and want them to be part of it. It can only be successful if the targeted audience, are part of this program. So we expect that all relevant stakeholders and all the people that have been invited to this, the general public, should be part of it, because it is designed for them. The ECOWAS Court of Justice is a community court, and it belongs to the community citizens and and member states.
Mr. Tony Anini Miado, Chief Registrar, ECOWAS Court, thank you so much for being with us this afternoon on this special broadcast. Mr. Nketia Apriku, Executive Assistant to the President of the Court, thank you so much for being with us this afternoon. My name is TETEE Fuka GEBRO. Don't forget, members of the ECOWAS Community Court of Justice are here in Liberia. They are on an outreach. They will be meeting with, high ups in government, and they'll also meet with women groups, students, lawyers, and it is our duty as citizens to also pay attention to these things so we know our rights as citizens. Thank you for watching, and have a wonderful time.
This is Julian No Shake It with Flavor. My original root boy, Mr. Flavor, partner dancer alongside Julian and D. Oyolima, Daniel, Liberia, another one. Liberians, the war is over. Let's celebrate peace.
Mastercraft on the beat.
Liberia is mama.